This is Kenny Tian. Welcome to Real Estate License in 14 Weeks. This is episode 34 of Starting from Zero. We continue with chapter 9 and complete chapter 9. If you like my video, please give me a thumbs up, subscribe to my channel, hit the bell for further notifications, share this video with your friends. Options by an agent. Options by an agent refer to a situation where the agent gets the listing. At the same time, the agent asks the seller to give the agent an option to buy the seller's property for a certain price. Options by an agent or listing with an option, it's legal provided the following two conditions are met. Number one condition, in dealing with the buyer, the listing agent must disclose to the buyer if and when the listing agent is acting as a principal. The second condition is the listing agent must disclose all material facts to the seller. What that means is the listing agent must be truthful to the seller about the market price and about the profit that the listing agent would make if the option is exercised. Contingencies. In a real estate purchase, normally the buyer would have certain contingencies such as inspection, appraisal, or loan. What that means is that if the buyer is not satisfied with the condition of the property after an inspection, or the buyer is not satisfied with the appraisal value, or the buyer could not get his or her loan, the buyer has a right to cancel. Whenever there is a contingency, you will see words like offer subject to, offer contingent upon, or offers condition upon. Those are all phrases that are used to describe that the buyer has contingencies in his or her offer. Next, interim occupancy agreement. What is an interim occupancy agreement? Let's say we're in a scenario as follows. Buyer and seller enter into a purchase contract. Before close of escrow, the buyer made a request to the seller to allow the buyer to move onto the property before the escrow closes. That is something that happens once in a while. It is possible that the buyer may have no place to stay because the lease that the buyer entered into has just ended and the landlord wanted the buyer to move out. So in order for the buyer to make this deal work and in order for the seller to make this deal work, buyer has to make a request to the seller to allow the buyer to occupy the property without title to the property. So possession will happen first, title comes later. In order to make it work, it is advisable to sign what we call an interim occupancy agreement. The word interim, it could mean temporary. It could mean that it's only effective for a certain period of time. So interim occupancy agreement is a type of agreement that the buyer and the seller will enter into to allow the buyer to take possession first. Now, in order to protect the seller, the interim occupancy agreement will talk about liability or relief of liability against the seller if the buyer should suffer injuries during the occupancy. The interim occupancy agreement will also provide for responsibility for maintenance and responsibility for insurance and things like that. Interim occupancy agreement is also commonly tested in the Department of Real Estate exam. Structural pest control certificate. Structural pest control actually refers to termite. These days, in the standard form, the seller is not required to provide structural pest control certificate to the buyer anymore. So if you represent the seller, you are not required to provide that certificate unless the buyer put it in the offer as a condition for close of escrow. If the buyer wants the seller to provide structural pest control certificate, it must be something that has to be negotiated. Now, if it is successfully negotiated, then the condition is in the purchase contract. Now, if there's a condition to provide structural pest control certificate by the seller to the buyer, then it is the responsibility of the seller or the listing agent or the seller's agent to deliver a copy of the termite report to the buyer. The termite report must be delivered before close of escrow. Disclosure responsibilities of brokers and sellers. This is a law that is named after the case Easton versus Strassburger. under Easton versus Strassburger, both the seller and the brokers have the duty to inspect the property. It's a visual inspection. So basically the seller and the agent will walk around the building and then note certain observations about any defects on the property or anything that would be a material fact to the buyer. So both the listing agent, selling agent, and the seller would have to comply with this law. However, the inspection is only limited to areas that are accessible and does not include areas that are normally and reasonably inaccessible. For example, agents and the seller are not required to go to the roof to check the roof because the roof would not be accessible and would not be normally accessible and reasonably accessible. What if it's a basement? Well, if it's a basement that is not lit, in other words, has no light, then that will be considered to be not reasonably accessible, and therefore agents are not required to go down to the basement. What if the basement is lit and there is a stairway so you can actually turn on the switch, allows you to go down to the basement? Well, in that case, the basement will be considered accessible and an agent would be required to do a visual inspection of the basement. The form that is used to make such disclosure to the buyer is called the transfer disclosure statement. The sellers and both brokers are required to fill out the transfer disclosure statement, which consists of several pages. However, because the amount of space that is provided by the form to both agents are very limited, so usually the agent will sign a separate form, and that form is called the Agent Visual Inspection Disclosure, otherwise known as AVID. Now, on the Agent Visual Inspection Disclosure form, brokers, in other words, the listing agent and the selling agent, will walk around the house and then jot down whatever observations that they make would be important to the seller. For example, a broken fence, a leaky roof, things that are material, things that are visible to the eyes. Now, this is a very important exam question in DRE. I forgot to mention when I talked about the transfer disclosure statement. A transfer disclosure statement is required to be given to a buyer only for certain types of properties, and it's only for 1 to 4 unit residential property. In the exam question, they may ask you, what if the property is a mixed-use property? Now, for those of you who are not familiar with mixed-use property, what that means is downstairs is all shops, upstairs is residential units. The exam question might ask you if it's a mixed use and the upstairs consists of 1 to 4 units. In this case, are you required to provide transfer disclosure statement to the buyer? The answer is yes. The timing of providing this disclosure to the buyer. The law says that the transfer disclosure statement must be provided to the buyer as soon as practicable, but before close of escrow. As soon as practicable but before close of escrow doesn't mean it's 1 day before close of escrow. Because as a seller, you don't want the buyer to have to wait until before close of escrow to get the transfer disclosure statement. Because after the buyer receives the transfer disclosure statement, the buyer has 3 days to cancel the purchase contract if the transfer disclosure statement was delivered to them by hand. And the buyer would have 5 days to cancel the purchase contract if it wasn't delivered by hand. For example, if it was mail, email, or some other type of methods. So other than hand delivery, the buyer would have 5 days. Hand delivery is 3 days to cancel the contract. So from the seller's perspective, the earlier you let the buyer have the transfer disclosure statement, the better it is for you. If the buyer is going to want to cancel based on the disclosure, at least you find out sooner and not as we get close of escrow. I need to add this to the topic on transfer disclosure statement. Frequently, it is tested in the exam about the 2 possible exceptions to the providing of transfer disclosure statement to the buyer. Even for 1 to 4 unit residential properties, a seller is not required to provide transfer disclosure statement to the buyers on the following 2 exceptions. Number 1 exception is if the sale involves a probate or trust sale. Because in a probate or trust situation, the person who is the seller is not really the person who has lived there. Probate or trust refers to the death of the owner of the property, and then someone else would have to help him or her sell the property. And that person has never lived on the property. Therefore, it is not practical for this person to complete the transfer disclosure statement and then provide it to the buyer. So that's one exception. The second exception has to do with a bank-owned property. If an owner can't pay the mortgage, the bank will foreclose on the property. So after the property is sold at an auction, if nobody bought the property, then the bank will receive title to the property. Now, when the bank receives title to the property, it will be sold at its REO department. So when it's sold at its REO department, it will be offered to the public for sale. During an escrow, a bank, even though the bank owns the property, but the bank has never lived there, it's not required to provide a transfer disclosure statement to the buyer. Mello-Roos Bonds. What is Mello-Roos Bonds? In some areas where the housing communities are newer, there may be certain types of special assessment. A special assessment is additional taxes that the property owner would have to pay if the property buys a home in an area where there is Mello-Roos tax. Purpose of the Mello-Roos tax is to come up with financing through sale of bonds by the local government to the general public. And the sale of bonds is actually financed through special assessment. So in other words, the government, in an effort to develop a community, and in order to fund the development, there should be money that will be used to finance police, school district, fire department, and so forth. And because of that, if a buyer buys into a property that has Mello-Roos tax, the actual property taxes will be higher than one that has no Mello-Roos tax. It is the seller's responsibility to make this disclosure to the buyer. Earthquake fault zone refers to areas where there might be earthquake faults. And one of the exam questions has to do with the name of the zone. It's called alquist-priolo. It's an exam question. So when you talk about earthquake fault zone, you should think about alquist-priolo. Same thing when you talk about alquist-priolo, you're talking about earthquake fault zone. If a building is 1 to 4 units, and if it's built before 1960, the seller and the listing agent will have to provide a copy of the homeowner's guide to earthquake to the buyer. Flood hazard zone. It is also the seller's responsibility to disclose to the buyer if the property is located or not located in a flood hazard zone. For exam purposes, there might be an exam question on the DRE that talks about the frequency of flood. Flood is considered to be frequent in a flood hazard zone if it happens more than 1 in 10 years. And flood is considered to be infrequent if it occurs 1 in 10 or more years. Next is military ordnance. Military ordnance refers to location where there is military gunpowder or explosive, such that there might be concern about explosion or chemical contamination. So this is the type of facilities that must be disclosed to the buyer if it's within 1 mile of the property. If a home is built before 1978, then there is always risk that the home may contain lead-based paint. So if a home is built before 1978, there's a law that requires the seller to make disclosure to the buyer about lead-based paint. Wildland fire area refers to areas that might be wildfire. If a property is located in an area that is wildfire hazard, it is the seller's responsibility to disclose to the buyer. The purpose of this disclosure is to let the buyer know about the hazard so that the buyer will be able to purchase the necessary insurance to protect against wildfire. Next, landslide hazard. If a property is located in a landslide-prone area, it must be disclosed to the buyer. If a property is located in a landslide hazard area, that must be disclosed to the seller would have to disclose that information to the buyer. If a property contains certain environmental hazards such as asbestos, radon, lead, formaldehyde, and mold, these are the type of disclosures that would have to be made to the buyer during an escrow transaction. This is the end of episode 34. See you next time.